Welcome to the CRREA Project's training videos on regulatory advocacy for legal services attorneys. This video series is produced by the Consumer Rights Regulatory Engagement and Advocacy Project, CRREA Project. This training was originally provided to legal services attorneys in partnership with the Shriver Center on Poverty Law, Legal Impact Network, and Racial Justice Institute Network. To find print materials of the visuals presented in this training, visit our website at www.creaproject.org. In this video, Diane Thompson presents on the power of commenting and how to submit a comment in a federal rulemaking.
So today we're going to talk about commenting. It is what most people think of when they think about regulatory advocacy. It's sort of the bread and butter work, although certainly not all of what you should do and not always the most impactful piece of the work you can do. And for those of us who are lawyers, it is a particularly accessible kind of regulatory advocacy because we're used to writing and making arguments in written form. So this is the goals map document that we have at CRREA Project. We looked at it a little bit last time. The goal is to help you see at a glance what the whole overall regulatory advocacy system is and what the time frame is and what you can engage with at various points in time. Commenting falls into the pre-rule and the proposed rule stage. Once you get to final rule, you're done with commenting, you're on to other kinds of advocacy. And you'll be commenting on advance notices of proposed rulemakings, requests for information, and proposed rulemakings primarily. One point that's critical for all of us is just to remember, again, I don't think we can say this often enough. It is your comment that makes the most difference. It is what you know. This is not some magic secret sauce. This is really about what it is you know, and it is the most effective comments are the ones that are focused on your particular unique knowledge, passions, interests. Form comments are not super effective, but one comment can make a huge difference in what happens in the rule. So it's not voting. Agencies don't have to tally up the number of comments and whoever submitted the most comments wins. And often that's good, given that we are often outmatched by industry or by other interests who, can submit more comments than we possibly can. So it's not the number of comments, but it's a single carefully thought out comment can change the outcome. So agencies ask for comments, as we said. You'll see them ask for comments in the notice of proposed rulemaking, in the request for information, and an advance notice of proposed rulemaking. All three of these get published in the Federal Register. You will probably hear them pushed out to you in your networks from places like Shriver Center or the National Housing Law Project or the National Employment Law Project. They all will have published comment periods, which are usually have to be at least 30 days unless the rules are being issued on an emergency basis. We have on the CRREA Project website this one pager, which is really the basics of how do you comment. And that's linked to other documents we have. It walks you through like what's the basic structure, what's the basic information that you need to put in, where do you go to find the rules, how do you submit it. There are a couple different places that you can find it, but the main thing to remember is like you go to one of these two sites, you make sure that you know when the comment period closes, how long you have to submit your comment, and tell the agency what it is you have to say. If your comment's long, you'll want to give them some context and some structure. So a table of contents can always be helpful. And so a table of contents is always helpful if it's more than a couple pages. You want to have your recommendations up front, and you should always say, like, why are you commenting? What's your expertise? Every single one of us has expertise in something. We know something that we know better than anybody else on this call, and we know something that we know better than anybody at the agency does, and that's what our expertise is. And whether that's you work with this specific population, or you have done this particular research, or you have this particular insight. You want to highlight up at the top why the agency should listen to you. So what's the right answer? So again, this is the question, like people say, what should I say in the comment? What is the one thing that I'm supposed to say? And the agencies are actually looking for the right answer when they publish requests for comment. They want to know what the right answer is. They're looking for an answer that is legally sound, that is effective, and that is supported by the record. And all three of those prongs are required by the Administrative Procedures Act and also by most state versions of the APA. And so when you're thinking about what you want to comment on and how you want to frame your comment, you're going to want to be thinking about, is what the agency proposed, is it legally sound? Is it effective for the purposes that they said they were trying to solve? And have they supported it in the record? And you also want to think about how you want to support in the record your interventions. So what are the pieces of evidence that you can bring to bear on why they should adopt your proposal? Your job as a commenter is to create the record for the agency to rely on if they need to defend the rule in court, and also to make it harder for the agency to ignore the comment. I saw in the Jamboard, somebody was saying, in law school, it seemed like it didn't really matter about comments because they don't have to adjudicate them. And agencies are required to read every comment and to respond to all the ones that are not substantially similar. So that's why you don't want to think about form comments. You want to think about what your own unique contribution is, because they don't have to respond to the form comments. They can just say, oh, these are all substantially similar, and put them to one side. But all of the ones that are unique, they have to read, they have to think about, and they have to respond to and identify, here's what the issues are. How do we think about this? And if they don't respond, if they don't give adequate consideration to those issues, their rule will be arbitrary and capricious and can be struck down. Oops. Okay, so the next thing, this is this Venn diagram that I told you about. And when we shopped our materials around to a bunch of former regulators, they all got very excited about this because they said this intersection between what you know and what agency rule writers do not know, that is exactly the place where you can be most effective in your comment. Agencies, when they put out a proposal, they have a hypothesis. They have a hypothesis about what the state of the world is. They have a hypothesis about what the problem is. They have a hypothesis about what the right solution is. You want to put your information of what you know that they don't know is the place where you can really change the game, where you can influence them. They are looking for the things that they don't know. And even if they aren't looking for them, if you've given them something that they don't know, they have to respond to that. So both in terms of getting them to shift their focus on what they're doing or to help them build their record, you're giving them what it is you know that they don't know is the very most effective thing that you can do in a comment. In general, what agencies are looking for from your comment is something that they can't get without your help. And that is often, for most of us, for many of us, for many of you, for people that work with marginalized communities, it's the experiences of the people you serve and how the rule will impact their lives. That's information that's very difficult for agencies to get on their own. They can really usually only get that information if you provide it to them. It's also true about, we've often gotten questions about, does it matter if we have state level groups comment? Does it matter, should we have Attorney General's comment? What's that role? And those comments can be very important because what they do is they can provide the granular information about what the state law is, what the state practices are, and provide that information to the federal agency. So the federal agency can say, oh, I see the foreclosure timeline in your state is really different than what we assumed the foreclosure timeline was. So our loss mitigation rules really won't work the way we thought they would. So that state level information, wherever it comes from, is very, very important. You're always wanting to paint a picture for the regulator about how your clients' lives will be improved or harmed by the proposed action. You don't want to stop by saying you support or oppose a rule. That, again, commenting isn't voting. It's not enough for them to tally up how many people support it or how many people oppose it. They need to know why, and they need to know what the outcome is. Because again, under the APA, they're required to say, what's the problem? And is the solution that we're proposing, is it going to be effective? And, always, are there unintended consequences? We often tend to think about unintended consequences as the impact on businesses, but unintended consequences can be just as often the impact on your clients, the communities that you serve.
Thanks for watching. Visit our website at www.creaproject.org for additional materials on how to do effective regulatory advocacy. We'll walk you through basics like how to write an effective comment letter, and some more advanced topics like how to plan your advocacy strategies using the unified agenda and how to think about agency guidance documents. Get in touch with us at www.creaproject.org to provide feedback and let us know what other materials would be useful to you in your advocacy.